Good evening. My name is Alex Long, and I'm here to begin the debate on the Patriot Act. In this debate, the affirmative will be covering specific sections of the Patriot Act which they find to infringe on the civil rights of the public and will argue for the revision of said sections. These sections include, but are not limited to, Sections 203, authority to share criminal investigative information, Section 206, roving surveillance, Section 215, access to records and other items under the Foreign Intelligence Surveillance Act, and Section 213, authority for delaying the notice of the execution of a warrant. The first topic we shall be debating is Section 203, authority to share criminal investigative information. This segment allows the federal government to share any electronic, wire, or oral interception information amongst its departments at any time. Despite the fact that this process of information sharing is important to monitoring terrorist activity and counterintelligence, this power is flawed because the process of information sharing lessens precautions that protect the privacy of an individual's information, said by Risa Berkelauer, a writer for the Fordham University Law Review in 2005. Section 203 of the Patriot Act states, the Attorney General shall establish procedures for the disclosure of information. Though this section of the Patriot Act may be beneficial, there is a flaw which is still unaddressed. The Attorney General is the only specified safeguard for the wrongful disclosure of innocent civilians' information. A critic of the Patriot Act, Keith Galloway, a lead attorney for Williams Mullen, an international law firm, stated that the safeguards regarding the procedures for the disclosure of information should be strengthened, meaning that without more checks put into place, the possibility of innocent civilians being monitored, there's a higher possibility of innocent civilians being monitored by the government. While we understand that we cannot fully eliminate the ability for federal agencies to share files with one another, our proposal for the amendment of this section of the Patriot Act would be to specify what types of information are shareable under Section 203, which in turn would limit who and under what circumstances sharing information would be acceptable. The second topic we will be debating is Section 206, roving surveillance authority under the Foreign Intelligence Surveillance Act of 1978. The affirmative's main focus will be on roving wiretaps. This section amends a law in the U.S. Code which originally stated that wiretaps could only be performed on suspected criminals. Now, with a court decision, the government can tap those related to a suspect in hopes of gathering incriminating information on him or her. This change in U.S. Code allows for innocent people to be tapped. This can occur when citizens inadvertently purchase supplies or aid a terrorist without their knowledge. This inadvertent act of kindness by a citizen can cause the government to generate suspicion about the individual and conduct surveillance on them. Used in conjunction with Section 203, the government will be able to share the information collected on these related persons and generate databases on the innocent individuals caught helping the wrong person. We would like to propose the complete elimination of Section 206 of the Patriot Act to return federal code to its previous wording, limiting wiretaps so they can only be performed on criminals of the country rather than those related to the criminal. The third topic of our debate will be Section 215, access to records and other items under the Foreign Intelligence Surveillance Act. Controversy around this act mostly focuses on the topics concerned with the seizing of library records, people's phones and email records, as well as financial data and the internet sites they serve, as written by Hope Yen, a writer for the Pittsburgh Post-Gazette. With power given by Section 215 of the Patriot Act, the government is allowed to ask libraries and bookstores for information and search purchase history. The government is also free to obtain material relating to terrorist activity, such as a computer in the case of a library in Florida, where FBI agents seized 2 computers from the Delray Beach, Florida library because they thought some of the September 11th hijackers used public computers to communicate, said an article by Fox News. This collection of materials by the government has a high potential for being abused and infringes upon the First Amendment rights of the United States citizens. We wish to amend Section 215 of the Patriot Act by putting in place protective measures for libraries and bookstores, protections restricting access to the search history only access to search history of innocent civilians, and only allowing the access of convicted criminals or terrorists will help put the public at ease over the government of what information the government can access. Additionally, we hope to add a subsection to subsection 215, forcing the government to explain the reasoning for requesting records for a specified library. For the final section, we will be debating section 213, delaying notice of the execution of a warrant, known to many as a sneak and peek warrant. To obtain a regular warrant, federal officials must be beyond a reasonable doubt that the target is a criminal. Officials must then acquire a warrant from a judge. After procuring a warrant, the warrant must be presented to those on the premises of the target building. They then can search for incriminating evidence and take anything on the premises which they feel would lead to a proper accusation of this person. This process differs from a sneak and peek warrant in that no person needs to be informed or on the premises when the warrant is carried out. Also, with a sneak and peek warrant, the federal agents are not allowed to take any tangible material, but only take photographs. This infringes upon the public's Fourth Amendment rights, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, and in turn should be amended. We plan to amend this section of the Patriot Act by abolishing the changes Section 213 of the Patriot Act makes to the Federal Intelligence Surveillance Act, and only can be used under the guidelines set in this Act. Again, we plan to amend Sections 203, 206, 215, 213. Thank you very much.